Welcome to Once Upon a Case, because the law isn't just for lawyers, it's for everyone. Quick thought experiment. If I tracked just your cell signal pings for a few months, I'd know where you sleep, where you work, who you visit, even what church or clinic you go to. Creepy, right? In 2018, the Supreme Court looked at that exact problem in Carpenter v. United States, and it changed digital privacy law in a big way. Here's the setup. The FBI was investigating a string of robberies. They asked phone companies for historical cell site location information, CSLI, for suspects. That's the breadcrumb trail your phone leaves when it pings nearby towers. No warrant, just a court order under an older law, the Stored Communications Act. For one suspect, Timothy Carpenter, they got 127 days of his location logs. That's tens of thousands of data points. He argued, this level of tracking is a search under the Fourth Amendment, so the government needs a warrant based on probable cause. The government said, hold up, the third-party doctrine. That rule comes from older cases like Smith versus Marilyn Miller, which basically say, if you voluntarily share info with a company, like dialed phone numbers or bank records, you can't expect the same privacy. The Supreme Court split 5-4. The majority, led by Chief Justice Roberts, said historical CSLI is different. Your phone is almost a feature of human anatomy, and it tracks you constantly without any real choice. Accessing that depth of data, days, weeks, months, creates a detailed chronicle of your life. That triggers the Fourth Amendment. Translation, for historical CSLI, the government generally needs a warrant. This ruling is narrow. It's about historical CSLI, not every kind of digital record. It didn't overrule Smith or Miller. Real-time tracking, tower dumps, and other tech weren't fully decided here. And emergency exceptions still apply. Think bomb threats or active kidnappings. Why this matters? Nearly all of us carry phones, and location data is insanely revealing. After Carpenter, police shifted to warrants. Courts wrestle with geofences and app-based data brokers. Bottom line, your phone's past location trail usually requires a warrant. Thank you for watching. If you learned something new, hit the subscribe button, and I will see you on the next episode.